this man.
I'm not the one that hit y'all son. I know how to lose a loved one.
Offender then the child in the stomach before this child.
Kyle Williams, a convicted killer, is facing a life sentence for the murder of a Lakeland police officer. A jury has recommended life in prison without the possibility of parole for him. Williams is returning to his jail cell, where he will stay until he is transferred to a state prison, his new permanent home.
We, the jury, advise and recommend to the court that it impose a sentence of life imprisonment upon Kyle Devonta Williams.
Upon hearing that the jury spared his life, 21-year-old Kyle Williams, a convicted killer, showed no signs of relief, nothing at all. However, his siblings managed to smile, and later, his attorney recognized this as a small victory for the defense.
Anytime you save a client's life, that is something very important.
Just days earlier, the same jury found Williams guilty of premeditated murder in the shooting of Officer Arnulfo Crispin. During this phase of the trial, they had only two options to recommend to the judge: life imprisonment or the death penalty.
Didn't expect the verdict to come out this way.
Crispin's family pleaded for the death penalty, believing it was the only appropriate punishment for someone who murdered an innocent police officer. Now, they are trying to focus on the positives, seeking closure nearly 3 years after the tragic event.
I think that my mom and dad and all of my brothers and sisters will bring that closure, will come to realize, you know what? He has no life from now on. He's going to be locked up forever.
The trial has been an emotional roller coaster for the Crispin family, filled with highs and lows, including today's sentencing. Two men with violent pasts are now accused of shooting a girl on a playground. Today, 18-year-old Sylvester Lewis appeared in court, restrained and in shackles. He was combative towards the deputies and even swore at the judge.
This man.
Lewis has been arrested 15 times, facing charges such as robbery, burglary, and battery. The second suspect is a convicted murderer. Court records reveal that this suspect is no stranger to crime. He spent 10 years in prison for killing a teenager in 2003 during a dispute over a borrowed gun. The 28-year-old was released just last year.
What are they doing out here in the community?
Durrell White is deeply concerned about career criminals roaming the streets. He joined Sierra Gon's relatives in a walk through the neighborhood where the girl was critically injured in a gun battle.
I think it's an injustice to the family that lost their child before, and it's also an injustice to the community.
District Attorney John Chisholm acknowledges that there is no simple solution to the tens of thousands of cases he manages yearly.
We have to make an appropriate determination what's the best thing to do with this person.
Some criticize Chisholm for being too lenient on crime, while others question why Wisconsin has one of the highest incarceration rates for black males in the country.
Ultimately, our obligation is to hold the person accountable, and you do so with the best evidence you have.
Lewis violated his probation after being released for burglary. State records show he had 9 violations while on probation, including fighting, verbal threats, and drinking. He ended up back in jail and was released last October. Since then, police report that he has been involved in at least 3 shootings, including the playground incident where a girl was shot in the head. A teenager charged with the death of a football player in 2019 learned his fate today. The incident came from a dispute over a video game. It was an emotional moment. Joshua Ingram, a 17-year-old who played football at Miami New Orleans High, was considered a rising star with a promising future in the sport. His family was inconsolable upon hearing the verdict for their son's shooter. Enkram's childhood best friend, Detron Phillips, shot him during an argument over video games. Both families were present in court, expressing that this was a tragic accident and emphasizing that the boys were best friends. Phillips was arrested on the day of the shooting and tried as an adult. He was sentenced to 364 days of boot camp and a short jail term, followed by 10 years of probation and community service, where he will speak to high school students about gun safety. While it was an emotional outcome for both families, it provided some closure after 2 difficult years. An 18-year-old man who pleaded guilty to shooting and killing a woman in Dayton has learned his fate. Robert Jones will spend 36 years to life in prison for the crime he committed. The victim was a divorced woman living alone. Jones, accompanied by his attorney Anthony Van Oy, appeared in Montgomery County Common Pleas Court to hear his sentencing.
Just turned 18 very recently. Any sentence that Your Honor were to give Robert would be significant.
Dayton police reported that during an attempted robbery, Robert Jones Jr. shot 75-year-old Tacky Gangloff in the head on Norwood Avenue. Her body was discovered by a bus driver.
I'm sorry for what I've done to the victim. And I feel very remorseful. If I can go back in time, I'd do it all over again. And I'll take it all back.
Jones's attempts at redemption did not persuade Judge Stephen Dankoff, though he did acknowledge Jones's troubled childhood and the fact that his father, Robert Jones Sr., is also in prison serving a sentence for murder. Despite this, Judge Dankoff emphasized that the murder of Tacky Gangloff was particularly disturbing.
The court cannot help but note that the death of this 75-year-old woman who waited on a bus alone in the darkness. Her life was taken, and for what? For absolutely no purpose that I can think of.
Jones's other crimes committed after the Gangloff shooting did not help reduce his sentence. Police reported that he was involved in additional robberies and the intimidation of a crime victim.
The court hereby sentences the defendant to a mandatory prison term of 30 years to life for aggravated murder and 3 years on the firearm specification to be served consecutively and prior to the 30-year life term on count 3.
Since the victim, Tacky Gangloff, had no family, members of the Dayton Homicide Squad came to court to show their support for her. An Albany man who stabbed a 20-year-old woman to death last year has learned his fate, but not without causing a commotion in court. 29-year-old Michael Anderson has been sentenced to 45 years to life in state prison. However, he didn't go quietly. Our cameras captured the dramatic outburst as it unfolded.
Hurry up and sentence me. You have a history of escalating. History with this and that and the third and Let's go. I'm already sentenced.
In Albany County Court, Michael Anderson had an outburst directed at Judge Stephen Herrick during his sentencing. On February 3rd, Anderson pleaded guilty to 1 count of second-degree murder and 2 counts of first-degree assault for the stabbing death of Tonight Thomas. On November 26, 2012, Anderson repeatedly stabbed Thomas with a knife at a home on Myrtle Avenue in Albany and also attacked 2 other victims. We spoke with Thomas's father, who was present at the sentencing, to get his reaction to the events in court.
Bunch of bull, you know, his games that he tried to play. He's still a boy. He ain't grow up to be a man yet, you know. So here it is, you know, 45 years, and I pray to God that he don't come back out. I pray he die up in there.
Between November 15th and November 20th, 2012, Anderson also repeatedly threatened members of the victim's family. Shaquan Oliver, a co-defendant in this case, was sentenced to 15 years in state prison in March. 5 people were taken away in handcuffs after an argument erupted just minutes after Antonio Watson was sentenced to 37 years in prison. Martell Gray II, Robert Macklin, and Shamar Bodine were shot at the Whitney Young Estates in Dayton. Gray died, while Bodine and Macklin were wounded but survived. As a result, Antonio Watson will spend a long time in jail. On his final day in the Montgomery County courtroom, Watson approached the bench to hear his sentence.
It's been a long, hard, and extremely sad 11 months for us.
He listened intently as he faced the family of Martell Gray II. The Dayton man Watson was convicted of shooting to death last September.
I truly wish you would have thought about how much pain you was inflicting on others while you were chasing these 3 young men down.
Despite denying the accusations, Antonio Watson asked the judge for leniency and sought forgiveness from Martell Gray II's family.
I know deep down in my heart I'm not guilty of the charge. I'm not guilty of the crime I'm convicted of. But I was wondering if you can give me if you can show a little sympathy. And to Mook's family, I'm not the one that killed y'all son. I know how to lose a loved one.
Judge Barbara P. Gorman sentenced Watson to 37 years to life in prison. After the sentencing, tensions between the families, which had built up during the emotional week-long trial, boiled over into altercations and further accusations. Outrage over the decision spilled into the hallway outside the courtroom and onto the sidewalk. 5 people were handcuffed, arrested, and taken to jail for disorderly conduct. Watson's attorney has announced that his client will appeal sentencing. A man sentenced to death for killing 2 Tampa police officers nearly a decade ago is now seeking a new trial. Dante Morris was convicted of killing officers David Curtis and Jeffrey Kokab after being pulled over for a traffic stop in 2010. During the 2013 trial, a jury viewed dashcam video of the shooting and sentenced Morris to death for the killings. Morris's lawyers are arguing that his first trial was unfair, claiming that the key witness, Ashley Price, lied. In a court hearing, the defense questioned Price about her cooperation with the state to avoid jail time on a separate conviction. They also brought in Marcus Oglesby, a friend of Morris, who claims he was with Morris the night of the shooting, potentially providing an alibi. Oglesby was never called to the stand in the first trial. The state will present witnesses later this week, after which the judge will decide whether a retrial is warranted.
Can avail himself to whatever appeals process he would like or file for a new trial, but the outcome will be the same.
Dante Morris is currently serving life sentences for 2 other murders for which he has been convicted. A man who admitted to murdering 2 people and attempting to kill another during a robbery in St. Pete has learned his fate. About a half hour ago, Gaddafi Mullins was given the death penalty by the judge. The judge stated that, based on all the factors in this crime, under Florida law, the defendant has forfeited his right to live. Gaddafi Mullins sat in court, sometimes smiling and other times looking down, as Judge Philip Federico recounted the events of August 2008. Mullins had pled guilty and waived his right to a jury trial, leaving the decision of a life sentence or the death penalty in the judge's hands. During the robbery at the Central Food Mart in St. Pete, Mullins and an accomplice shot and killed the owner and another customer, then shot a 3rd customer who survived. The violent crime was caught on surveillance camera, which played a significant role in sentencing. Both Mullins' family and the victims' families were present in court. They declined to comment afterward. Both families had been waiting for 5 years for a resolution in this case. The trial of a former police recruit accused of raping at least 8 women will move forward. Prosecutors allege that the only time Killen Bowen III wasn't committing these assaults was during his 10 months of military service. Bowen, a former Clayton County police recruit, is accused of rape and child abuse. The incidents, which took place in an area of Clayton County, are alarming and graphic. In court, 24-year-old Bowen appeared unbothered, while a detective detailed the rapes of at least 8 women. Among these victims was a woman who was 9 months pregnant.
Knife was brandished and she was forced to give oral sex. Vaginal penetration in this case took place for approximately 2 hours.
The court then heard about another victim.
1-year-old child was in the bed with her when she was assaulted. That was also vaginal penetration from. She stated that he had an approximate 6-inch knife that was used and held to her throat, and threats were made to harm her child that was in the bed with her if she did not cooperate.
The prosecutor stated that in each case, Bowen used a weapon to intimidate his victims. One victim recounted how Bowen threatened that his friend would harm her child in the next room if she didn't comply.
She actually had an 8-year-old child who woke up in the residence from her making noise and attempted to block his mother's doorway when he seen the offender try to flee from the residence, and the offender then the child in the stomach. Before this child fell to the ground, he stepped over the child and fled from the residence.
As background on the case, police say Bowen committed these crimes around South Lake Mall. They linked him to the assaults using DNA evidence. We attempted to speak with his attorney, but were unable to reach him. We also tried to talk to Bowen's family as they were leaving the courthouse, but they declined to comment. Dwight DJ Grant was killed in October, and for months, the teenagers accused in this case have been kept in jail. However, one of their attorneys attempted to get his client released on bond.
She stood right in my face and she said she didn't know what happened to my son. She stood right in my face. I don't know if he was still alive, but I could help him.
For the first time since their son's murder in October, the parents of Dwight DJ Grant, the 18-year-old from Miramar, who police say was killed by 3 other teens in the stairwell of his apartment complex, speak.
The defendant chose to deprive me, his family, his friends of his life.
During the hearing, DJ's parents spoke about Christine Paritzian, one of the teens accused in this case. As her attorney tried to secure her release on bond, it was revealed that Paritzian had no idea DJ would be killed when she lured him outside his apartment. This led him to Andre Clement and Joseline Smith, who police say stabbed him to death.
Evidence points to she was manipulated to being involved in this without knowing that a murder going to take place.
However, the state, armed with hundreds of pages of texts between Paritzian and Clement, argued that she knew exactly what was happening. The texts revealed a twisted, dark attraction to violence shared between the teens in their digital exchanges, suggesting that Paritzian was complicit in the plan that led to DJ's death.
This case on October 3rd, she says, "I love your opinion and all, but it's spooky season and my toes will be red to represent the blood I'd be stepping on after I viciously someone to."
The court will deny bond. The judge denied bond for Paritzian and held a status hearing for Clement and Smith earlier to ensure all 3 cases remained on track. In court, DJ's parents were visibly emotional. His mother shared that she has been unable to return to her job as a nurse in the Memorial Healthcare system since the incident. She also expressed fear for her life if these teens were to be released from jail. A vicious attack on a teenage girl outside of a library left her paralyzed and blind. Kendrick Morris was initially sentenced to 65 years in prison, but a court ordered his resentencing because he was a teen when the crime occurred. The judge issued an even harsher sentence. At the time of his original sentencing, the law prevented him from receiving a life sentence due to his age. However, that law has since changed. With his fate again in the hands of a judge, a clear and decisive judgment was made.
Life sentences are the only appropriate sentences in this case.
Kendrick Morris received a life sentence for the brutal attack that left a woman paralyzed and blind 9 years ago.
I want to say that it's a victory, but it seems wrong to say that.
Kendrick Morris showed little emotion as the judge read his life sentence. Afterward, the loved ones of the woman he nearly killed shared an emotional embrace.
I believe justice was served, but in the end, both lives now are sentenced to life.
Life in prison is the outcome, a decision not desired by Kendrick. In 2008, he raped and brutally beat a girl outside of a library, leaving her paralyzed and blind.
I know that she needs the closure.
The closure has been hard to find for the victim and her family, who continue to pray for it, as they did over the weekend. Initially, Morris was sentenced to 65 years without parole, but because he was a juvenile at the time, he was required to have the possibility of parole and was ordered to be resentenced. During the resentencing, the judge reviewed Morris's crimes, which included another rape in 2007. Though the judge could have shortened the sentence, he instead lengthened it. The judge became emotional as he recounted the harrowing details of the case.
He was unresponsive. Having suffered major injuries.
Always difficult to relive that day, and but it's just a reminder of how horrific the crime was.
It's a reminder she faces daily, and not even a sentence can change that.
It's not over. It's going to be a lifetime commitment, taking care of my sister.
Ariel Adam Montgomery was convicted of murder and other charges by a jury in February. He waived his right to appear in court after jury selection began, but he will be required to be present on his sentencing for his crimes. The jurors spent more than 2 weeks listening to emotional and graphic testimony during Montgomery's murder trial for the death of his daughter. He was convicted of second-degree murder, second-degree assault, falsifying physical evidence, abuse of a corpse, and witness tampering. Montgomery was only present for jury selection, and his absence was noticeable from the opening statements to the reading of his guilty verdict. In a motion filed by his attorney, Montgomery maintained his innocence regarding the murder, assault, and witness tampering charges, and requested to be excused from attending his sentencing. In response, the state referenced another murder case where a law was passed requiring the the killer to appear in court when the victim's family addressed the judge. The judge highlighted that Montgomery's only factual basis for excusal was his assertion of innocence, despite being found guilty beyond a reasonable doubt by a jury. Adam Montgomery will be sentenced on May 9th in Manchester. A Miami County murder sentencing took a twist when a family showed up to claim their loved one was also a victim of the defendant. Donald Pepper found out he'll be serving 15 years to life in prison for one murder, but neighbors and others we spoke with believe it wasn't his first. A wheelchair-bound Donald Pepper was taken from the Miami County courtroom, likely never to regain his freedom. For some, the sentence is long overdue.
In the end, it comes back to bite you, and it has come back to bite him.
Pepper had pleaded guilty to killing his 65-year-old roommate, James Wolfe, after initially telling 911 operators that it was a lawnmower accident. Prosecutors portrayed Pepper as a man who had exploited Wolfe to obtain money from him before brutally killing him. As shocking as the story sounds, one family claims it follows a familiar pattern.
This was not his first time. We really do believe in our hearts that he did the same thing to Penny.
Friends and family of Penny Jenkins were present to witness Pepper's sentencing. They recounted how he moved in with Penny, who was 30 years his senior, less than a month after her husband died. Shortly after that, they were married.
He started becoming verbally abusive. We could hear it, but you could never see anything.
Penny later died, and friends say Pepper had her cremated immediately. No charges have ever been filed against him in Jenkins' death, but those close to her are convinced he was responsible and believe he should have been stopped sooner. One friend remarked, "Maybe if somebody would have listened to us, it wouldn't have gotten that far." John Kalish showed no reaction when a judge sentenced him to death. The judge stated that Kalish methodically planned to murder whoever was inside his sister's Brooksville home in 2010. After his arrest, Kalish told investigators that he blamed all his legal troubles on his sister and wanted to erase her and her bloodline. These statements were used as evidence against him. He was found guilty of murder in a trial that took place back in January in Brooksville. It was up to a judge to deliver the sentence. During the trial, Kalish wore a suit and had shoulder-length hair. The convicted murderer walked into a Hernando County courtroom dressed in jail attire, his head shaved, awaiting his ultimate fate. After finding Kalish guilty, the jury unanimously recommended the death penalty.
Aggravating circumstances in this case are appalling.
Judge Daniel Merritt agreed with the jury's recommendation and sentenced John Kalish to death.
John William Kalish, you've not only forfeited your right to live among us, but under the laws of the state of Florida, you have forfeited your right to live at all.
Kalish had already pled guilty and was sentenced to life in prison for gunning down a Dixie County deputy who was attempting to arrest him. He is now sentenced to death for shooting and killing his sister, Catherine Donovan, and her employee, Deborah Tillotson. This incident occurred 2 years ago. 2 other women survived the rampage, and one of them managed to call 911.
Oh my God, I'm shot in the stomach and the shoulder. Help, please!
The families of those who died that day chose not to speak after the sentencing, but Tillotson's family friend, Harriet Hogue, stated that justice was served.
There's going to be closure for them. Before, it was really tough not knowing what was going to happen. But now that there's closure, I think they can get on with their lives.
Kalish's attorney attempted to avoid the death penalty for his client by arguing that Kalish's life was in turmoil, that he snapped, and that he had a history of alcoholism in his family. Despite these arguments, Kalish showed absolutely no emotion during sentencing. 49-year-old Richard Rokowski was sentenced to death for a 2006 triple murder that occurred in Bridgeport. Although Connecticut repealed the death penalty 2 years ago, Rokowski was still sentenced to death. Connecticut has 2 capital felony laws, the old one and the new one. In this case, the old law still applies. Rokowski was sentenced to life in prison for the murders of his former girlfriend, Holly Flannery, and 38-year-old Thomas Godet, whom he mistakenly believed was romantically involved with Holly. Rokowski received the death penalty for the murder of Holly's daughter, Kylie.
Hearts break every time one of Kylie's would-be milestones happen. A life never lived. It's all too sad, and it should have never happened.
In my heart, I know Holly and Kylie's fears are gone because they are at peace with God. So for Mr. Rokowski, I want that same fear to stay with him as he sits in his little room, waiting to die, but also knowing that his will be with him for eternity in hell.
Judge John Blowy scheduled Rokowski's execution for October 1st, but that's largely a formality. There's an automatic appeal process, which can be nearly endless.
I'm truly, deeply remorseful for what happened, and I'm truly, deeply sorry for the pain that I have caused to you and to all the family members.
Rokowski received the death penalty because the crime was committed before the death penalty was repealed 2 years ago. When the legislature passed the repeal, they made it prospective, meaning it applies only to future crimes. This decision was influenced by the desire to use the death penalty on the 2 men convicted in the 2007 Cheshire home invasion murders. The repeal would not have passed without this provision. Currently, the state Supreme Court, Connecticut's highest court, is considering whether this prospective application conflicts with and violates the constitutional rights of the men on death row. This is the case of a double murderer who needed money for a wedding and attempted to frame one of his victims for his deadly deeds.
It is the order of this court that you shall suffer the penalty.
Convicted Orange County killer Daniel Wozniak has been sentenced to death for his role as the mastermind in a gruesome double murder. One of the victims was their son.
My only regret that in this state won't let me kill this coward myself.
In 2010, Daniel Wozniak lured Samuel Hare to a theater where he murdered and dismembered him. Prosecutor Matt Murphy demonstrated that Wozniak then shot Hare's girlfriend, went to an ATM to withdraw money, and took the stage for a performance. The following day, Wozniak killed a friend of Hare's to mislead police and throw them off his trail.
There's no word to describe our pain and anger and frustration we have been going through. That will never heal or go away.
There was more drama in the courtroom as the judge criticized Daniel Wozniak's public defender for filing a 132-page document seeking a new trial. It took both sides all morning to present their arguments, and in the end, the 32-year-old Wozniak was sentenced to death. Brandon Bradley, the man convicted of murdering Brevard County Sheriff's Deputy Barbara Pill in 2012, has been sentenced to death.
Brandon Lee Bradley, you have been given the opportunity to be heard and show cause why judgment should not be imposed and offer matters of mitigation. This court has considered the aggravating and mitigating circumstances presented and has prepared a comprehensive sentencing order which is on file with the clerk. No legal cause has been shown to preclude the imposition of the judgment and sentence. This case involves a completely senseless murder of a law enforcement officer who was simply fulfilling her duties as a public servant by initiating a traffic stop to investigate the Econo Lodge robbery as reported by its motel owner. Deputy Pill acted professionally with the defendant during the traffic stop and provided him countless opportunities to exit the vehicle over the course of 3 minutes. Never did Deputy Pill take her phone out of its holster, draw her phone, or threaten the defendant. The bottom line is that the defendant, Deputy Pill, in a selfish, foolish, and futile attempt to avoid returning to prison for violating his probation. The defendant planned well in advance of the of Deputy Pill that he would do what it took to avoid incarceration, even if this entailed using a gun to shoot an officer. Despite ample time for reflection, to abandon his plan to avoid arrest, and even being urged by his then girlfriend and trusted friend, Andrea Michelle Kirshner, not to shoot Deputy Pill, the defendant did so regardless. The defendant chose not to just shoot Deputy Pill one time, but off 7 more shots. The defendant's brazen, premeditated, callous, and cowardly action of Deputy Pill multiple times on a public street in a neighborhood of congested single-family homes mandates nothing less than a death sentence. Therefore, Brandon Lee Bradley, as to count 1, you are judged guilty of the crime of first degree for the unlawful killing of Deputy Barbara Pill. For this crime, the court sentences you to be put to death in the manner prescribed by law. As to count 2, you are judged guilty of the crime of robbery. For this crime, the court sentences you to serve a term of imprisonment in the Department of Corrections for the state of Florida for a term of 15 years. As to count 3, you are adjudged guilty of the crime of fleeing or attempting to elude a law enforcement officer, siren and lights activated with high speed or reckless driving. For this crime, the court sentences you to a term of imprisonment in the Department of Corrections for the state of Florida for a term of 15 years. As to count 4, you are judged guilty of the crime of resisting officer with violence. For this crime, the court sentences you to serve a term of imprisonment of 5 years in the Department of Corrections for the state of Florida. These sentences are to run consecutive with each other. The defendant is entitled for credit for time served of 844 days as calculated by the clerk. You are advised that this judgment and sentence shall automatically be appealed to the Supreme Court of the state of Florida. Defense counsel is directed to perfect the appeal. The public defender is hereby appointed to represent you on appeal. Should you not have private counsel or are unable to afford private counsel, you are hereby remanded and without bail to the custody of the sheriffs of the Brevard County to be delivered for commitment to the Department of Corrections, where you will be confined until final execution of this judgment and sentence prescribed by law. Mr. Bradley, may God have mercy upon your soul. This court is now in recess.
Judge has sentenced Aries Tisdale to death for the murder of St. Lucie County Deputy Morales.
In carefully weighing the aggravating factors that were established by the state beyond a reasonable doubt against the mitigating factors established by the defense, it is not simply a quantitative analysis, but is a qualitative one. It is this court's duty to look both at the quality and the nature of the aggravating and mitigating circumstances which have been established. Under such an analysis and upon reflection and consideration, the proven aggravating factors substantially outweigh the mitigating statutory and non-statutory mitigating factors. Therefore, Aries Alfonso Tisdale, as to count 1 of the indictment, first degree of a law enforcement officer with in the lawful execution of his legal duties, it is the sentence of this court and the judgment of the law that you be sentenced to the first degree murder of Sergeant Gary Morales. As to count 2 of the indictment, aggravated assault on a law enforcement officer while in possession of a the court sentenced you to serve 15 years in the Department of Corrections. I am required to impose a 3-year minimum mandatory sentence as required by Florida law. As to count 3, will adjudicate you guilty of possession of firearm by a convicted felon. Sentence you to serve 15 years in the Department of Corrections to run consecutive to the sentence imposed on counts 1 and 2. You'll also be given, I am also required to impose a 3-year minimum mandatory sentence on that offense. As to count 4 of the indictment, fleeing and eluding, the court adjudicates you guilty, sentence you to serve 5 years in prison to run consecutive to the sentences imposed on counts 1, 2, and 3. You'll be given credit for 1,156 days served by you on that sentence up until today. I'll assess the statutory required court costs, $100 cost of prosecution, and the public defender costs as made reference to earlier without any further court hearing. It is further ordered that you, Aries Alfonso Tisdale, be taken by the Sheriff of St. Lucie County to the Florida State Prison and there be kept in close and secure confinement until the date of your execution is set. It is further ordered that on such time as scheduled by the Governor of the State of Florida, at the place of execution named in the Governor's warrant of execution, you be put to You are hereby notified that the judgment of conviction and sentence of death are subject to automatic review by the Supreme Court of Florida. You are further advised that you have the right to the assistance of counsel in filing and preparation of your appeal. If you wish to have counsel appointed for your preparation of your appeal, you may advise the court through your lawyer, and then counsel will be appointed on your behalf. You have 30 days, sir, to file an appeal. If you're unable to afford a lawyer, one will be appointed to represent you. Thank you, sir. That's all.
Well, it's all good. God got the last say so. Yeah, for you, dog.
Thank you all very much. We'll be in recess. Thank you for bearing with me.
A judge sentenced convicted quadruple murderer Adam Matos to spend the rest of his life behind bars.
That means one person on that jury felt enough sympathy, mercy for you that they decided that you did not deserve that penalty. So for that, I don't have to make that decision. It's not something that I ever wanted to do or wished to do. But if there was ever a case that I've ever heard that 12 people would have decided that death was appropriate, this is probably it. But that's their decision. I believe wholeheartedly in the judicial system, and I believe that those 12 people made up their mind, and that sentence will be imposed on you. But I also agree with the victims in this case. This was the most selfish, self-centered, evil thing that I've ever heard. That you took the stand and you said that you did all of this for your son is ridiculous. Your son was in the house when this occurred. He was either in the room or within 65, 70 feet of when you shot his mother, shot his grandfather, and then waited 5 hours, by your own admission, to walk downstairs and beat his grandmother to death. In those 5 hours, you must have sat in that house with your son. He was there. It's 6 o'clock in the evening. He's not asleep. He's not locked in his room. You're sitting there with your son, with his mother, his grandfather, and a man who gave his life for those people. You sat there with him and went downstairs and finished off his grandmother. And you did that for your own selfish reasons. Maybe it was your age. Maybe it was that you felt that they had done something to you that you needed to get revenge for. But there was no remorse. Just saying you're sorry doesn't make it so. You're not sorry for what you did yet. Maybe someday you will be. You weren't sorry that day. You weren't sorry when you took the stand, and you're not sorry now. Your son will grow up without a mother, and without grandparents, and without a father, just as you did. But worse than you, he will grow up without a father because he will know that his father murdered his mother and murdered his grandparents. There's no worse life than that. Hopefully, with the love that he has from the Piles and the Browns and all the other family relatives that he has, he will learn to understand and be happy and learn the things about his mother that he did not know because you took her at such a young age of his. There's nothing worse than losing a parent at a young age, but to have them taken from you by your father, I can't imagine. So hopefully, some way, somehow, through the love of the family that he has here, he will grow up to be a healthy, happy, productive, hardworking, loving person. But that's not because of you. So to say that Tristan is your whole world, I don't believe that. I don't believe Tristan was your whole world. I believe that you did this because you were selfish. And based on the decision of the jury, I sentenced you in count 1 and count 4 to life in prison without the possibility of parole. In counts 2 and 3, I sentenced you to life without the possibility of parole. However, that's with discharge, include charging, which means hopefully that no matter what happens with the legislature, no matter what we decide on life or death in your case, you will never, ever be released from prison. Can you afford to hire an attorney for your appeal?
No, Your Honor.
All right, so at this point, I will appoint the public defender to represent you for appeal. State, is there any costs associated that you're asking me to impose?
Mario McNeil has been sentenced to death for the 2009 murder of Shania Davis. Before the formal sentence was pronounced, Shania's father, Bradley Lockhart, addressed the court and spoke directly to McNeil. After the sentence was imposed, we spoke with Cumberland County DA Billy West and Art Pope, one of McNeil's defense attorneys.
All right, defendant, please rise.
foreperson please stand?
Madam Clerk, please take the verdict.
Madam Foreperson, the jury has returned as its verdict as to the issues and recommendation as to punishment as to the defendant, Mario McNeil, and file number 09-CRS-66040. As to issue number 1, yes. As to issue number 2, yes. As to issue number 3, yes. As to issue number 4, yes. The jury has returned as its recommendation as to the defendant, Mario McNeil, that he be sentenced to death. Is this unanimous recommendation of the jury? So say you all by raising your hand.
Court sees 12 hands. Thank you. You can have a seat. Defense may have a seat.
Brad Lockhart, L-O-C-K-H-A-R-T. It's been a long road. You know, but at the end of this verdict, nobody's really won here. You know, I can never get Shania back. You have taken that from me. The passage of time, these 43 months, has not healed or diminished this pain, this grief, this hurt that I live with every day. I think about those last seconds, and you was the last thing my daughter got to look at. Made a mockery of this court, laughing and joking like this was a joke. Shania wasn't a joke. Shania has touched so many people, not just my life, but so many people's out there. And you've tried to destroy it, but her legacy is going to live on. You didn't win. I could be angry and hateful towards you. It's not going to fix this problem. You didn't win. Shania won because she's still going to be speaking out, protecting people against people like you. Other little kids. The media's glorified you as you walk in the courtroom with your little antics and your smirks and your smiles, waving your hands around like you're free at last, but you ain't free. I'm not going to worship you, I'm just going to pray for you.
The prisoner, Mario Andretti McNeil, having been convicted in the first degree by verdict of the jury, duly returned at the term of Superior Court of Cumberland County, North Carolina, and the jury having unanimously recommended punishment, it is therefore ordered and adjudged that the same Mario Andretti McNeil be, and he is hereby sentenced to, and the Sheriff of Cumberland County, North Carolina, in whose custody the defendant now is, shall forthwith deliver the said prisoner, Mario Andretti McNeil, to the warden of the State Penitentiary at Raleigh, North Carolina, who the warden shall cause the said prisoner, Mario Andretti McNeil, to be put to death as law provided. May God have mercy on your soul. You can have a seat. All right, stand up, Mr. McNeil. You did not have to kill that child. Take him out of here now. And I want to say to Shania's family, I apologize. I apologize for referring to Shania as the victim, for talking about Shania's body. I apologize for you having to go through any of this. I can't give you justice. This jury has given you what we as humans, the best we as humans can do to give you justice. Justice would be if I could reverse all of this, and I can't. I've said a prayer for you every night of this trial, and I will continue to do so.
Judge Michael Traynor sentenced Johnny Lawrence Williams Jr. to life in prison for the murders of 24-year-old Jamie Antoinette Wilson and 18-year-old Kiwun Javante on the 19th of July 2016 in the St. Johns County Courthouse.
Sorry for the pain I caused.
Why?
So sorry, my
Did you get locked up for the rest of your life? Ladies and gentlemen, I recognize this is a very emotional situation, but I need you all to please be quiet.
And most of all, I want to say sorry for my mom for letting her down. That's it.
All right, thank you. Williams, based on the indictment presented by the grand jury, and you're having entered a plea of guilty to count one to the charge of first-degree premeditated, a capital offense, is the order of judgment and sentence of this court that you be committed to the Department of Corrections for the rest of your natural life, for a period of your natural life, without parole. That as to count two, based on the indictment filed by the grand jury, and you're having entered a plea of guilty to the capital offense of first-degree premeditated and/or felony murder, is the order of judgment and sentence of this court that you be adjudicated guilty of that offense, as you were adjudicated guilty of count one, and that you be committed to the Department of Corrections for a term of your natural life. That as to count three, you're having entered a plea of guilty to the life felony charge of attempted first-degree murder with a firearm. The order of judgment and sentence of this court that you be adjudicated guilty of that offense, that you be committed to the Department of Corrections for a term of your natural life. That, Mr. Williams, did you hear and did you understand that sentence? Was that consistent with what you understood the plea agreement to be?
Yes, sir.
We love you no matter what.
You
failed. You failed your son. No, I have not failed my son. Let me had nothing to do with what my son did. I'm going to love my son death to his heart. I love him. That's my only child. I know this. I don't care about
Karen was hoping for a lighter sentence, but her actions led to the maximum penalty. Seriously, what did she think would happen after she attacked the judge?
According to the plea bargaining agreement, punishment is to be assessed at 7 years in the prison. They're recommending community supervision, and there are items to be taken in consideration. Deferred adjudication.
The reason why the state is opposed is because of the nature of offense, the actual underlying facts. The resulting assault it created a lot of issues for the complainant. Her life was severely impacted. It's something that was senseless and didn't need to happen in the first place. So that's why the state is opposing deferred and is asking for probation.
Defense.
Your Honor, we're here because one incident can't define the person, and this is very serious. This is a felony charge, very significant. But Ms. Segundo, I think, has a respect not only to others. Rarely do I have an opportunity to where a client will provide 32 letters of reference about how wonderful she is. That is the life that she defines herself with. We just feel like this should not define her as a felon for the rest of her life. She's really fighting to be able to continue to provide the love and the support of 4 children that need their mother. This case is 2 years old, and it's been 2 years that she has been experiencing this, and she has complied with everything this court has asked. She has fully cooperated and sought not to seek a trial, but to put the decision on deciding her future on you. She is willing to do everything and anything that it takes to give her this opportunity.
Well, just so you know, in this court, I see everybody as a human being. For me, defendants are not defendants. They're human beings who are accused of a crime. The fact that Rebecca Martinez is a judge, that doesn't mean that I'm putting weight on the fact that she's a judge. I'm just dealing with the facts here. And my job is to look at everything objectively and not what people's occupations are. So I always reread everything in the PSI report, and I've read the letters. I do not understand the fact that an elevator has a limited capacity. People saying the elevator is full, you cannot be in an elevator too. For example, if there's an elevator, I think everybody knows there's a weight capacity on the elevator. When I see there are too many people on the elevator, I don't get on. Obviously, what we are here now for is there's an elevator. According to everything that I've read, the elevator was at capacity. I don't understand how an elevator is at capacity. People need to get off or more people can't come on.
I couldn't tell you how it started. Just somebody in my party was getting into it. Somebody hit me and I just reacted. Shouldn't have got to that. It just happened.
I know things happen quickly. The police report I'm reading, it doesn't say that somebody in your party, you got hit and so therefore you got into a fight. What your counsel is telling me, somebody in your party, I guess, was in a fight and then you decided to get involved.
I went to go and try and pull my friend away and then, I don't know, it was just a bunch of people and somebody hit me and I just reacted.
I think the facts is this is a COVID era. These elevators can accommodate 18, 20, 22 people. And as people went into the elevator, the policy and procedures of the elevator operator of not allowing people to come in once they met capacity.
Judge, just to clarify from the states, I would disagree with the characterization of how the incident started. The complainant's party was already on the elevator. They were asked to not enter the elevator. They weren't kicked off. They were asked not to enter.
Unless there are some facts that are listed in the
It leaves
lawsuit.
the whole case, Your Honor. Exactly what you're talking about.
I mean, if that document has facts that somebody has, alleged facts that somebody has presented, that's a different rendition from what's in here. Ms. Segunda, I've listened to all arguments. I want you to know I paid very close attention into all of the documents that the court reviewed. I realize that sometimes when things happen, it's just a Snapchat or somebody's life. And I'm sure if people could go back and change things, sometimes people are serious when they say, if I could go back and change things, I would. I would have just let the elevator went. I would have taken the stairs, but we can't turn back the hands of time, right? All right, this is what the court is going to do. Court will find you guilty. There's a $500 fine. There's a transfer to Houston. There's to be restitution of $2,416. I don't see this as an anger management situation. I see this as an aberration. She doesn't need anger management. All right, we can go off the record. What I've learned in my time on the planet, it's just best when somebody says, oh, you can't do that and you want to argue about it, pick another day to argue about it. You understand?
A dispute about the upstairs neighbor allowing their dogs to use the bathroom on the balcony above turned into a legal battle.
Please don't feign outrage. You know what the lawsuit's about, and don't call out while she's testifying. Go ahead.
I don't have a dog. I live on the second floor. The neighbors who lived above me before, they had a dog. I never had an issue.
The situation escalated to the point where the plaintiff ended up in the emergency room due to high blood pressure. Even though she had doubts about the story, the judge wasn't pleased with the behavior of the two defendants.
Excuse me. You're giving me a perfect flavor of what the hallway was like, because if in a courtroom you can't control yourself, I can only imagine what the hallway is like.
Throughout the case, the defendants glared at the plaintiff, pretended to be outraged, and showed the exact behavior they were accused of. They even tried to smile at the judge, but it didn't fool her or anyone else watching. It was almost funny to see them try to act innocent while misbehaving.
And she
Okay.
made gestures like she was going to do something to us.
What were the gestures that looked like
just bucking and yeah,
Like
exactly, just like that.
chicken necking?
Plaintiff Teresa Hopster definitely seems to have a strong desire for followers in heaven to help anyone who stands in her way.
Well, my best friend planted these flowers when we bought them.
And what kind of flowers are
They're Asiatic black wizard lilies.
She remains cool and collected as she recounts the story of a savage flower massacre by the defendant's landscaping company. But once the defendant presents evidence of Harpster's behavior, which includes some minor assault and a torrent of obscene language, her look of shock is almost comical.
She would like to weed whack the kid that cut her flowers and weed whack Bill for hiring someone with no brains. The head of South Village doesn't care and is a liar.
It's also somewhat alarming. The longer it goes on, the harder it is for her to contain her frustration. Her temper only becomes more evident despite her insistence that everyone is lying about her. Her final words to the defendants are as unhinged as they are amusing.
God'll get you.
Landscapers hired by a homeowners association mercilessly hacked down a bed of rare lilies, and plaintiff Teresa Harpster wants justice by any means necessary.
Went like that, and it never even touched
What does
him.
went like that mean?
Oh, the flower that I had in my head, the dead one, just went like that.
Did
to
you
him.
throw it at him? Is that what you're saying?
I didn't really throw it at him.
What were you doing?
I just wanted to show him to look at it.
She glosses over the part where she yelled and threw flowers at the landscaper's employee, but we eventually get the whole story. Harpster gasped and stood open-mouthed as the judge read statements from the employee she verbally harassed.
At the tip top of her lungs, which she proceeded to push me after that. She said, if the company won't do something about this, I will. And I proceeded to walk away to avoid further conflict.
As the woman is confronted with her own outrageous behavior and comments, it becomes clear she's barely containing her anger, even with the judge. Who knew one could be so passionate about Flora?
I never used any profanity against that young man or him. I never met him until today.
All right. One other question I never heard discussed. Will the lilies grow back?
No, they did not grow back.
It wasn't him. He was just following orders. A website developer was sued over defamatory and disgusting allegations against the plaintiff, an advocate for internet safety.
Like, I understand what you're saying. Your argument is, oh, Judge, I'm just a website creator. That's fine if you create a website and hand the keys over. But you're the guy actually putting on the pictures.
The defendant's story about being hired by lawyers who wanted him to post the accusations didn't sit well with anyone, especially not the judge. Whether he was playing dumb or truly didn't realize he was guilty, the defendant's sulking did nothing to get him out of trouble. In fact, it only made the judge even more upset.
Nah, you're in control. No, you're not only in control, you're a horrible person because you're taking pictures and making them look like something that you know they're not because you have the real pictures.
He appeared to have no moral qualms about knowingly posting defamatory statements, and for him, Sora was just another job. This case hit close to home for another reason. Apparently, the plaintiff had a previous case that was heard by Judge Milan's husband, Judge Slinger.
Yeah, I didn't know that.
Yeah, that's my husband.
Okay, well then, it's a small world. Judge.
Wow! This is a first.
Judge Millian had no reason to expect that anyone in her audience could play the busted accordion at the center of this case.
Well, I asked for her to play it, but the thing was she came up with the excuse saying that it's missing cable.
Since none of the litigants can demonstrate how to play it, who can say if it is actually a defense? A wild accordion player enters the chat.
Does anybody in this room play an accordion? I do. Oh my gosh, for real?
It's a rare treat to see an audience member say anything, let alone put on a small concert for the room.
Side is working, the left is not.
We get to hear a little bit about how she learned to play, and let's say the judge's retort is best appreciated by those familiar with their post-World War history.
Did you start playing the accordion?
My family's from Argentina and they're German.
So oh my goodness.
Two sides.
You've said too much. Go ahead.
If you're curious, the plaintiff won the case and got his money back for the broken accordion. He ordered a thick crust but got a thin crust instead. This is his courageous tale.
You're asking for a refund of some money you paid for a pizza. You claim you didn't get the right kind of pizza?
Yes, I am.
An incredibly serious plaintiff would likely stand out in any case, but the fact that he's suing over a $3 slice of pizza makes this the least serious case ever, and that makes it all the more entertaining.
I paid a total of $3.73.
$3.73?
Yes, there is no price on the cookie, so I presume that the cookie was around 73 cents.
Meanwhile, the restaurant owner seems to have taken this as a chance for some free publicity more than anything else. Then again, with the way it's described, maybe the pizza really is worth all the trouble. Even the plaintiff can't help but give an enthusiastic review of the restaurant he just sued.
I did go to that pizza place because they are the best.
Big thanks to our viewers for joining the courtroom journey with us. Your interest in the stories of justice is what keeps our channel alive.